Okay, so now we're getting to some of the most, probably one of my most favorite parts of this entire course, and that's the Supreme Court making decisions, accepting cases. Love this stuff. I have taken multiple classes and gone to conferences about it. I won't go over everything, of course, because it's an AP general government class, but this is great stuff. I highly encourage you to read some books about it. So going from there, the courts as policymakers. Judicial decision-making, a former Supreme Court law clerk wrote in the Harvard Law Review, involves at bottom a choice between competing values of by fallible, pragmatic, and at times non-rational men and women in a highly complex process in a very human setting. This is an apt description of policymaking in the Supreme Court and in other courts too. The next section looks at how courts make policy, paying particular attention to the role of the U.S. Supreme Court, SCOTUS. Although it is not the only court involved in policymaking and policy interpretation, its decisions have the widest implication for policy. Okay, accepting cases. Deciding what to decide about is the first step in all policymaking. Courts of original jurisdiction cannot very easily refuse to consider a case. The U.S. Supreme Court has more control over its agenda. The approximately 8,000 cases submitted annually to the U.S. Supreme Court must be read, culled, and sifted. Figure 15.4 shows the stages of this process. At least once each week, the 9 justices meet in conference. With them in the conference room sit some 25 carts, each wheeled in from the office of one of the 9 justices, and each filled with petitions, briefs, memorandum, and every item the justices are likely to need during their discussions. These meetings operate under the strictest secrecy. Only the justices themselves attend. Okay. Everything that's on that cart, the judges aren't doing. They have law clerks. Many of them, the justices, were clerks. To get to the level of a clerk at the U.S. Supreme Court, or maybe even U.S. Appeals Court, is very prestigious. It is a very important part of the process of moving up in the ranks of the court system in this country, to get the top law jobs, to become attorneys at someone like Jordan Day. I think I can't remember. I think it's Jordan Day. You have to look it up. In Washington, D.C., it's a law firm. You want to get to the top, this is how you get there. How do you get to the clerkships? You got to go to the right law school. You got to go to Harvard, Yale, maybe even U of M, one of those top tier law schools. How do you get to one of those? Disproportionately, there are people who are coming from elite high schools and elite neighborhoods, elite communities. So it's a club. There's a club of people that end up there. You can break into the club, but you're going to have to work harder than they do because they're already in the club. So and they're good people. These clerks, they work really hard. It's a difficult job. It's a lot of hours, but you do it because you know where it's going to get you. And so meeting with them, I went to a conference and we met with clerks talking about, these are the men and women, young men and women who are working with the justices in picking cases. So what happens is, of those 8,000 cases, they're split up among the 9 justices and then divvied up among the clerks, and the clerks pick and choose and create very brief summaries of those court cases. So the justices are not actually reading those 8,000 cases. And the justices' clerks are picking what they should look at. And there is argument that makes those law clerks very too important to the process. Why are these young men and women deciding, making and breaking whether a court case is heard? But that is how it's done. I learned, and I don't know if this is true still, but Alito took on from who he replaced. There's usually one justice whose clerks look at all 8,000 cases. So the cases are looked at twice. If you end up on Alito, and if it's still Alito, you're going to have more work to do because you're looking at all 8,000 as clerks, while the others are spreading the 8,000 amongst each other. Got it? So then they meet. They meet together, the 9 justices, after looking at the summaries, and they're going to decide what case they're going to take. Okay. Before the meeting, Chief Justice circulates a list of cases to discuss, and any justice may add other cases. Because few of the justices can take time to read materials on every case submitted to the court, most rely heavily on law clerks to screen each case. Okay, so now they've picked and chose what cases they want to talk about. If 4 justices agree to grant review of a case, rule of 4, that's a test question, that's a big deal. Rule of 4, it is placed on the docket and scheduled for oral argument, and the court typically issues to the relevant lower courts or state court a writ of certiorari, a writ of cert, a formal document calling up the case. So you granted the case cert. In some instances, the court will instead decide a case on the basis of the written record already on file with the court. So court watchers are watching to see what cases are granted cert. In other words, which ones they're going to hear, so they're calling for the info from the appellate court. The cases the court is most likely to select are those that involve major issues, especially civil liberties, which is our next unit, Bill of Rights, conflict between different lower courts on the interpretation of federal law, as when a court of appeals in Texas prohibited the use of affirmative action criteria in college admissions, and a court of appeals in Michigan approves their use. We'll talk about all of that. Circuit split is a major reason why they take up a case. Circuit split, different circuit courts going with different decisions. We'll talk about that. You need to know it. Because getting into the Supreme Court is half the battle. It is important to remember this chapter's earlier discussion of standing to sue. Litigants must have serious interest in a case, having sustained or being in immediate danger of sustaining a direct and substantial injury from another party or an action of government. A criterion the court often uses to decide whether to hear a case. It's a good way to punt it. They've had cases where, well, in the end, they say, well, you didn't have standing to sue anyway, and then they don't have to make a decision. As we discuss later in this chapter, the court will sometimes avoid hearing cases that are too politically hot to handle or that divide the court too sharply. Many times they don't want to take it. They don't want to go there. They know that the politics are very emotional in the public, in the country right now, and they don't really want to touch an issue if they don't have to. And we'll talk about that more later too. Another important influence on the Supreme Court's decision to accept cases is the Solicitor General. This is a big deal. It's a test question. As the presidential appointee and the third-ranking official in the Department of Justice, the Solicitor General is in charge of the appellate court litigation of the federal government. So litigation or lawsuits, they're in charge of the Supreme Court, the federal government stance. The Solicitor General and his staff of about 24 experienced attorneys have 4 key functions: to decide whether to appeal cases the government has lost in the lower courts, to review and modify the briefs presented in government appeals, to represent the government before the Supreme Court, and to submit an amicus curiae brief on behalf of a litigant in a case in which the government has an interest but is not directly involved. What's interesting about Solicitor Generals right now is you go from Obama's Solicitor General, who is defending Obama's actions, then Trump is elected and his Solicitor General drops an appeal because they don't agree with Obama's stance. So now the federal government is dropping an appeal because you have a different viewpoint. And then now with Biden, the Solicitor General is going yet in a different direction on cases. So the politics, the heated politics, and I don't know how the history of this, if it's always been this way, but seeing it now, the whiplash that goes on whether or not the government wants to appeal a decision is pretty striking based on who the president is. Solicitor Generals are careful to seek court review only of important cases. You should say what they see as important cases. By avoiding frivolous appeals and displaying a high degree of competence, they typically earn the confidence of the court, which is turn grants review of a large percentage of the cases they submit. Often the court asks the Solicitor General to provide the government's opinion on whether to accept a case. This is a big deal, why they're called off the 10th Justice. If the Solicitor General is supposed to be a very respected position about dealing with what the U.S. government's view is on a court case, and therefore, if the Solicitor General wants the court to hear the case, saying that the federal government needs clarification from the court, then the court would usually oblige and hear the case. Remember, though, there has to be a case. It's not like the president goes to the court and says, well, can you clarify this for us? There actually has to be somebody with standing to sue in a justiciable dispute, something that can be decided by the court. And then it has to go through the process before the Solicitor General says, hey, we do need you to hear this case. Ultimately, the Supreme Court decides very few cases. In recent years, the court has made about 75 to 80 formal written decisions per year in which their opinion could serve as precedent and thus as the basis of guidance for lower courts. In a few dozen additional cases, the court reaches a per curiam decision. That is a decision without explanation. Such decisions resolve the immediate case but have no value as precedent because the court does not offer reasoning that would guide lower courts in future decisions. Keep in mind about those 8,000 cases, a good 50% of them are, to say disrespectfully, kind of garbage. You can file to have the Supreme Court hear your case, doesn't mean it has any merit, value, basis in reality, nothing. Just because you say, I want the court to hear it, and the court says, no, we're not going to hear the case. So it's just like looking at people applying for a job. Sure, 100 people applied for the job, but how many of those people are actually qualified for the job? So of those 8,000, much of it isn't even really, probably had no business being filed in the first place. And then it comes down to, though, is why do they pick, of the ones that do have value, why do they pick what they do? And we'll talk about that more in class. And most of it is educated, very educated, well-educated guesswork. Because they don't always tell you why they pick the cases, but people watch to see what the theme is and why they think they take the cases the way they take them. And again, we'll talk about that more in detail in class. The second task, first task is to pick cases and put them on their docket. The second task of the Justices' Weekly Conference is to discuss cases that the court has heard. From the first Monday in October until June, the court hears oral arguments in 2-week cycles. 2 weeks of courtroom arguments followed by 2 weeks of reflecting on cases and writing opinions about them. Figure 15.5 shows the stages in this process. Before the justices enter the courtroom to hear the lawyers for each side present their arguments, they have received elaborately prepared written briefs from each party involved. They have also probably received several amicus curiae briefs from parties, often groups, who are interested in the outcome of the case, but who are not formal litigants. As already noted, these amicus briefs may be submitted by the government under the direction of the Solicitor General in cases in which it has an interest. For instance, if a case between two parties involves the question of the constitutionality of a federal law, the federal government naturally wants to have its voice heard. Administrations often use these briefs to urge the court to change established doctrine. For example, the Reagan administration frequently submitted amicus briefs to the court to try to change the law dealing with defendants' rights. In most instances, the attorneys for each side have only a half hour to address the court. During this time, they summarize their briefs, emphasizing their most compelling points. The justices may listen attentively, interrupt with penetrating or helpful questions, request information, talk to one another, read, or simply gaze at the ceiling. After 25 minutes, a white light comes on at the lectern from which the lawyer is speaking, and 5 minutes later, a red light signals the end of that lawyer's presentation, even if he or she is in mid-sentence. Oral argument is over. You'll hear that Justice Thomas never talks, rarely talks during this, rarely asks, if ever. He went like years without asking a question or saying anything. And I was told at a conference that's because he doesn't like oral argument. He thinks it's just theater. These men and women who are sitting on the bench have already read about the court case. They've already started to think about it. Chances are they might be asking questions in order to clarify, but they know the real work is done behind the scenes when they write their opinions and they share their opinions with each other. This is not really the big part. We like to talk about oral argument um, in the media because it's the one time we actually get to hear them talk. It's not videotaped so far. It's not. There's no camera in the room, but there's audio, and it's all we've got. Most Americans don't like to sit around and read the details of a case. This is not where the real work is done, though. Oral argument is not where the real work. You're not going to learn everything in 25 minutes of someone arguing. Debating in front of you, or an hour's work total. Okay, but it's done. Back in the conference room, the Chief Justice who presides over the court raises a particular case and invites discussion, turning first to the Senior Associate Justice. Discussion can range. So the Senior Associate Justice is the one who's been there the longest. Discussion can range from perfunctory to profound and from courteous to caustic. If the votes are not clear from the individual discussions, the Chief Justice may ask each justice to vote. Once a tentative vote has been reached on a case, it is necessary to write an opinion, a statement of the legal reasoning behind the decision for the case. When they sit there, everything's done through seniority. So the newest person on the bench, which would be Barrett, is the one who if there's like a message that has to be given to someone outside, she's the one that's going to get up and get the message outside. Like there's responsibilities, and the lowest on the court has to do the lowest positions. Chief Justice, even if it's his first day, is by definition the most senior member of that court. Where they sit matters, how they talk matters, on who gives their opinion on opinion day is all done by seniority. Everything is done in this routine. And to the court, especially we all know from Chief Justice Roberts really cares about the integrity and the sanctity of the court. It's a really big deal as Chief Justice to him that there is process, procedure, respect. It doesn't have to be that way. You could have a Chief Justice to go in and just say whatever, but he's really big on that. Opinion writing is no mere formality. This is where the real work is done. In fact, the content of an opinion may be as important as the decision itself. Broad and bold opinions have far-reaching implications for future cases. Narrowly drawn opinions may have little impact beyond the case being decided. Tradition in the Supreme Court requires that the Chief Justice, if in the majority, write the opinion or assign it to another justice in the majority. The Chief Justice often writes the opinion in landmark cases, as Warren did in Brown v. Board and Berger did in U.S. v. Nixon. If the Chief Justice is part of the minority, the Senior Associate Justice in the majority assigns the opinion. The person assigned to write an opinion circulates drafts within the court. Justices make suggestions, and they all conduct negotiations among themselves. The content of the opinion can win or lose votes. A justice must redraft an opinion that proves unacceptable to the majority of his or her colleagues on the court. So this is where, hey, if you take that out, I can sign on this. If you add this, I can sign on this. I don't agree with that part, and nothing is. You all agree as majority. I'm going to write a concurring opinion. I agree, but I don't agree with this part. So I'll vote with you, but my opinion is going to be written differently. Back and forth, back and forth. That's why it takes months. It's not that they haven't already made their vote. They already know where it's going to go. It's the opinion, the writing the opinion, because the opinion becomes or can become precedent. It's the basis of that opinion in the history and where it's going to, how that opinion will be used that takes the time and why we end up waiting months. So when you go watch the court and you're waiting for big decisions, they usually tell you, and it's again usually in May or June, okay, we're 3 decisions. Once you get past, they'll start when they announce a decision, the most junior member of the court's decision is first. The last decisions will be the most senior. So the most important decisions are usually done by the most senior members, and that will be on that day. if Chief Justice Roberts gives an opinion on opinion days, remember there are argument days, but then there are opinion days where they give their opinions. They won't read it necessarily. It's just published and they announce it. Those days when the chief, you're waiting for the big ones, you're waiting for the last opinion of that day. An opinion you can go through 3 opinions in a half hour. They're not reading them. They're just saying, okay, in this case, this is our ruling. And then everyone talks about it who's actually reading the opinion behind the scenes because it's been released. Justices are free to write their own opinions, to join in other opinions, or to associate themselves with parts of one opinion and part of another. Justices opposed to all or part of the majority decision write dissenting opinions. Concurring opinions are those written not only to support a majority decision, but also to stress a different constitutional or legal basis for the judgment. So you write a dissenting opinion because even though your opinion is not what's going to become law, the hope is over time, someone will look at your dissenting opinion. Your dissenting opinion can become majority opinion. So think about cases that have broke with precedent. Plessy v. Ferguson, separate but equal. That obviously in the 50s and 60s was overturned. So they can look to the dissent. I don't even know if there was a dissent. I don't remember. But they can look to a dissent in Plessy v. Ferguson to say, we're actually thinking this is what is better precedent. So you do need to write your dissenting opinion. It can become valuable. With the Dred Scott case, where the majority opinion said that Black men and therefore Black women can never be citizens of the United States, dissent's valuable, but that opinion was overturned by constitutional amendment. Dred v. Scott was the overturn of that is the 14th Amendment. So how can you change a court's decision? Constitutional amendment. Can always do that, but usually that doesn't happen. You just have to get different people on the court. When the justices have written their opinions and taken the final vote, they announce their decision. That's usually months later. At least 6 justices must participate in a case, and decisions are made by majority vote. If there is a tie, because of vacancy or someone didn't participate, the decision of the lower court from which the case came is sustained. 5 votes in agreement of the reasoning underlying an opinion are necessary for the logic to serve as precedent for judges of lower courts. So you need 5 decisions for it to actually impact policy and law, future or current law, I should say. The basis of decisions. Okay, so how do they make their decisions? Why can you have one constitution and a law written and yet different people have different impressions on what the Constitution means and or what the law means or who the law applies to? And this is very important. Okay, I expect you to know this. Judges and justices settle the vast majority of cases on the principle of stare decisis. Let the decision stand, meaning that an earlier decision should hold for the case being considered. All courts rely heavily on precedent, the way similar cases were handled in the past, as a guide to current decisions. Lower courts, of course, are expected to follow the precedents of higher courts in their decision-making. If the Supreme Court, for example, rules in favor of the rights to abortion under certain conditions, it has established a precedent that lower courts are expected to follow. Lower courts have much less discretion than the Supreme Court. The Supreme Court is in a position to overrule its own precedents, and it has done so more than 200 times. One of the most famous of such instances occurred with Brown v. Board, in which the court overruled Plessy v. Ferguson, 1896, and found that segregation in the public schools violated the Constitution. Brown v. Board, which is discussed later as well, Plessy v. Ferguson said government could separate people based on race or color, skin color, as long as equal, separate but equal. Brown v. Board said that separate is inherently unequal in school settings, public school settings. You can't have equal if they're separated. Brown v. Board was school related. There are other rulings that extend beyond that. There's the Civil Rights Act of '64 that makes it illegal to segregate. So Brown v. Board didn't do everything and change everything, but it was a good start. What happens when precedents are unclear? This is especially a problem for the Supreme Court, which is more likely than other courts to handle cases at the forefront of the law, where precedent is typically less firmly established. Moreover, the justices are often asked to apply to concrete situations the vague phrases of the Constitution, due process of law. You're right. Due process of law means the law is applied to you through the steps. You get your day in court, due process of law. Equal protection under the law, unreasonable searches and seizures, or vague statutes passed by Congress. This ambiguity provides leeway for the justices to disagree. The court decides unanimously only about 1/3 of the cases in which it issues full opinions, and their values to influence their judgment. In contrast, when precedents are clear and legal doctrine is well established, legal factors are more likely to play a preeminent role in the Supreme Court decision making. We don't have, often with technology especially, the law doesn't keep up with new technology. How can, I will talk about in class that government doesn't need a warrant to take pictures of your backyard in a plane, because planes go over property and don't hover, and therefore they don't need a warrant. Well, now we have drones. So is it a Fourth Amendment violation for the government without a warrant to hover a drone over someone's property? Again, warrants usually make things okay. We don't know. That's where the courts come in. Someone is going to have to be prosecuted. The GPS decision that I can talk about in class about putting a GPS device and track someone without a warrant, is that kind of a violation of Fourth Amendment right? Spoiler, it is. These issues come up in front of these courts and Supreme Court because the law isn't. It's just too vague. It's just too new. They weren't making these decisions 100 years ago. And they certainly weren't thinking about them when they wrote the Fourth Amendment. Okay. The Constitution does not specify a set of rules by which justices are to interpret it. There are a number of approaches to decision making. One is originalism. Okay, this is Justice Scalia's baby. Justice Scalia is known for it. He's not the only one. He was big on talking about it. Other judges use it, but they use other ideas as well, like textualism, textualism was something that was used on a Native American treaty with the federal government by Gorsuch. So conservatives have their ways of interpreting, which conveniently fall in line with conservative values. And liberals have their way of interpreting the Constitution, which conveniently work for their political values. Okay, so the original intent theory holds that interpretation of a written constitution or law should be consistent with what was meant by those who drafted and ratified it. Justice Clarence Thomas is the most prominent advocate of this view. The original meaning theory is a view that judges should base their interpretations of a written constitution or law on what reasonable persons living at the time of its adoption would have declared the ordinary meaning of the text to be. It is with this view that most originalists, such as Scalia, are associated, original meaning being more discernible than the often nebulous original intent. So original intent is, what did they mean when they wrote it? Original meaning is, what did everyone at the time understand it to mean? A complaint about these is often these judges and justices and lawyers are not people with history degrees. Can you give me it's more what they think it was. There's often a conflict. Historians can kind of groan at some of it because oh no, that's not really what they were thinking. And there's conflict there. So are they even right when they say that was the original interpretation? Advocates of originalism view it as a means of constraining the exercise of judicial discretion, which they see as a foundation of liberal court decisions, especially on matters of civil liberties, civil rights, and defendants' rights. They also see following original intent or meaning as the only basis of interpretation consistent with democracy. Judges, they argue, should not dress up constitutional interpretations with their views on contemporary needs, today's conditions, or what is right. It's the job of legislators, not judges, to make judgments. In other words, they would argue we don't have a problem with something being legal. We just don't think it's constitutionally protected. Go ahead, have same-sex marriage, but you don't have a constitutional right to marriage. That would be their argument. Both of these theories share the view that there is an authority contemporaneous with the Constitution's or statute's ratification that should govern its interpretation. However, originalists do not propose to turn the clock back completely, is by, say, upholding a statute that imposed the punishment of flogging, which the Constitution framers approved. Of course, originalists often disagree among themselves about original meaning, and sometimes they agree about the founders' intentions, but disagree about overturning deeply rooted precedents, such as ban on segregation in school prayers. That may clash with those intentions. Moreover, even when there is broad scholarly agreement about original understanding, originalists sometimes ignore it. That's kind of what I was talking about, that they're not really always sincere about that. I would also say they claim to be judicially restrained, but if they have been known to strike down laws that Congress made, which based on their argument, Congress has a right to make a law, but then strike it down on original intention of the Constitution, which I would argue, and many others would argue, is still doing what the liberals are doing, which is making law based on your own desire what the law should be. And we'll talk about that more in class. The bottom line I'm saying here is both sides have a real difficulty. If you try to argue to me that both sides are sincere, that's fine. But if you try to argue with me that there's this genuine capital T truth to either side and that they always consistently follow their version of how to interpret the Constitution, I'm going to disagree with you, and I'm going to show you evidence of that. Because Scalia does also strike down laws that arguably should be upheld. Now, has conservatives, but they do often get an unfair target by liberals who are not aware of how the decision is made. Just because they strike down a law or an action, doesn't mean that the law can't be rewritten or that a law can't be made. They're just arguing that the Constitution doesn't protect said action. Having said that, keep in mind with originalism, there is, and we'll talk about later, the 14th Amendment. The Constitution has been amended. The 14th Amendment being a big one that cannot be ignored. And that will be the next chapter. Now, liberal justices or living Constitution justices, on the other hand, have their problems as well. And let's look at what their view is. The primary alternative does not have a clear label, but those holding it view the Constitution as written in flexible terms, as a document whose meaning is dynamic and thus changes over time. Advocates of this approach to decision-making, such as Breyer, he's still in the court right now, assert that the Constitution is subject to multiple meanings, to being given different interpretations by thoughtful people in different ages. Judges from different times and places will differ about what they think the Constitution means. Thus, judicial discretion comes into play, even if judges claim to be basing decisions on original intent. So everyone's doing it, in other words, despite what the other side's, we're all interpreting it with some of our own background. For advocates of this approach, originalism's apparent deference to the intentions of the framers is simply a cover for making conservative decisions. So, in addition, these jurists contend that trying to reconstruct or guess the framers' intentions or meaning is very difficult. Recent key decisions before the court have concerned issues such as campaign financing, abortions, the internet, and wiretapping that the framers could not have imagined. There were no super PACs, contraceptives, or modern abortion techniques, or computers, electronic surveillance equipment, or telephones in 1787. When the founders wrote the Constitution, they embraced not specific solutions but general principles, which frequently lacked discrete, discoverable meaning or intent. Moreover, there is often no record of their intentions, nor is it clear whose intentions should count. Those are the writers of the Constitution, those are the more than 1,600 members who attended the ratifying conventions, or those are the voters who sent them there. This problem grows more complex when you consider the amendments to the Constitution, which involved thousands of additional framers. Moreover, historian Rakov points out there is little historical evidence that the framers believed that their intentions should guide later interpretations of the Constitution. Now, I've also read that they thought, well, that's fine, the framers and the people at the time, just change it, add amendments. Just add amendments as you go. If you need clarification, make it flexible that way. In defense of the originalists, though, they aren't always saying that there shouldn't be a law. They're not saying that always saying that this is, we can't allow this. They're just saying the Constitution doesn't protect this. So the example is same-sex marriage. Do you see marriage as a right or a privilege? If you see marriage as denying two women from getting married, as violating their rights, because a man and a woman can get married, why not two women in a relationship? If you see that as a violation of rights, which is what the living Constitution or the liberals would see it as, then you would say you're violating their rights. And that's in I think it's the 14th Amendment that they apply to say that. And then the originalists would say, no, they never taught same-sex marriage is not a right, it's a privilege. It's done by law, and therefore it is not constitutionally protected. I personally would argue those are two valid arguments. They both have legitimacy. Other than that, I don't know what to say. That's why it matters who's on the court. Given the discretion that justices often have in making decisions, it is not surprising that consistent patterns related to their values and ideology, to conservative versus liberal positions, are often evident in their decisions. A number of scholars have proposed an attitudinal decision-making in which justices decide cases based largely on the outcomes they prefer, rather than on precedent or the meaning of intentions of the Constitution's framers or of legislators. In other words, they argue policy preferences matter in judicial decisions making, especially on the nation's highest court. I'm big on this one. If you couldn't already tell. When someone says, I don't believe in judicial activism, what they usually mean is, I don't believe in justices making decisions I don't agree with. They're fine with activism when they agree with the decision. I want judicial restraint means I want them to uphold laws and values and that I agree with. They don't want restraint when they want the law struck down. And I would say that's true of justices too. You find the model that gets you the decision you want. And I don't even know if that's really unfair. You're validating your decisions instead of saying, well, this is just what I want. You're placing value to it with an argument, and that has merit. In other words, they argue policy preferences matter in judicial decision-making, especially on the nation's high. I said that, sorry. Although precedent, legal principles, and even political pressures from the public, Congress, and the White House constrain justices' discretion, justices usually arrive at a decision consistent with their policy preferences. And I will end that one there.